In summary, the plaintiffs, community organizations, have brought this suit to prevent the defendants, a combination of banks and developers, from destroying a plaza that exists at 1800 Columbia Road Northwest in the district, or from otherwise interfering with the public's use and enjoyment of that plaza. Plaintiffs argue that the plaza, while presently owned in fee simple by SunTrust Bank, is subject to what's called a common law easement by public dedication, which prohibits the defendants from moving forward with the development. A proposed development of a mixed-use residential and commercial building that would substantially demolish the plaza and eliminate the vast majority of the public space that it provides. Through the present motion, the plaintiffs ask the court to enjoin the defendants from demolishing the plaza during the pendency of the lawsuit, which will ultimately determine the validity of their claimed easement. Now moving on to what I'm going to spend the most of my time talking about, the likelihood of success on the merits of this lawsuit. As I indicated a few moments ago, in order to prevail in the request for a preliminary injunction, the plaintiffs need to show they have a substantial likelihood of success on their claims. The plaintiffs have presented direct evidence of an explicit public dedication by Perpetual Federal Savings, the entity that constructed the plaza and the bank branch that had been passed on through the Resolution Trust Corporation and Crestar to its current owner, the defendant SunTrust Bank. When I speak of the direct evidence, I first of all refer to Ms. Marie Nahikian. Ms. Nahikian in the early 1970s was the director of the Adams Morgan Organization, or AMO, and later on became an advisory neighborhood commissioner. In her testimony, she described how the AMO and other local organizations originally opposed the opening of the Perpetual Bank branch and even filed an official objection to the bank branch's opening with the Federal Home Loan Bank Board and sent representatives to Atlanta to voice the objection at a board hearing. Eventually, the community groups withdrew their objection based on an agreement with Perpetual. Ms. Nahikian testified that this agreement was detailed and had multiple parts, including a portion in which Perpetual made assurances regarding its lending practices. But she also stated that Perpetual had agreed to construct its branch to include a plaza for public use. In her records, and I'm quoting what she said at the hearing, quote, "They agreed to design a building that would allow for continued, as we said, perpetual use of the public space as the kind of heart of the community at that location," end quote. She also noted that the farmers market was specifically listed in the agreement as part of the public uses that would be permitted. According to Mrs. Nahikian, this agreement regarding the design and use of the plaza was an important part, and these are her words, an important part of the consideration that the community received in exchange for dropping the official objection it had lodged before the government board. Secondly, as direct evidence of the intent of the grantor being Perpetual, the plaintiff also presented at the hearing the declaration of Frank Smith. Mr. Smith did not testify at the hearing. He was not subject to cross-examination, so this written declaration had much less weight than sworn-in testimony would have. The document itself is sworn and notarized, and I do find it reliable enough. As I said during the hearing, reliable enough to consider this in a non-trial proceeding, even if it was less weighty than in-court testimony would be. According to the declaration, Mr. Smith was chairman of the Adams Morgan ANC in 1976 and was personally involved in the negotiations with Perpetual regarding the creation of the bank branch and plaza. And he testified at the hearing in Atlanta referenced by Ms. Nahikian. In paragraphs 7 and 8 of the declaration, Mr. Smith stated, and again I'll quote, "After long negotiations, an agreement was reached with Perpetual Bank. In exchange for withdrawing our opposition to the opening of a Perpetual Bank at 18th and Columbia, Perpetual agreed to modify its lending practices and to dedicate the plaza portion of the parcel at 18th and Columbia for the continued use by the market and as a neighborhood open space. Specifically, Perpetual agreed to design its new bank branch building and a modest structure far back into the parcel to preserve the open space as a public plaza and provide accessibility to the vendors and general public for the holding of open-air public activities and to dedicate the plaza for public use," end quote. On top of that, at least some of the surviving documentation from the mid-70s corroborates the accounts of Ms. Nahikian and Mr. Smith. The parties have placed a lot of emphasis on their competing interpretation of Plaintiff's Exhibit Number 1, which was the letter sent to the community by Thomas J. Owen, the president of Perpetual Federal Savings, on November 2nd, 1976. According to the testimony of Ms. Nahikian, this letter went to all property owners in the neighborhood. The letter described meetings with the AMO, with the local business community, with the Spanish-speaking community, and with other civic organizations and states. Quote, "Following these meetings, Perpetual agreed to develop the property in such a way as to preserve its open quality, attractiveness, and accessibility to the vendors that presently use it." present plans call for a bilingual branch housed in a modest 3-story building placed as far back as possible in order to allow ample room for vendors and open-air activities. The letter also included a plea for members of the community to support the creation of the bank branch and enclosed a card for citizens to send back to express their support. The defendant's counsel made some interpretations of this letter I found to be fairly creative. I doff my lawyerly hat to you for that. But in the end, I found these explanations or interpretations of the letter to be fairly unconvincing. First, the defendants argue that the letter contained no explicit commitment to maintain the public space forever, but the letter describes an agreement to preserve the property's open quality. That's the verb that's used. So a verb that's certainly suggestive of continued use of the property. It's difficult for me to even conceive of the concept of temporary preservation as the defendants have urged me to. The defendants also contend that this letter only represents a promise to the vendors. They argue that the sentence, "Perpetual agrees to develop the property in such a way as to preserve its open quality, attractiveness, and accessibility to the vendors that presently use it," should be read to refer only to an agreement reached with the vendors. And, as the defendant correctly argues, if Perpetual did only make an agreement with or dedication to the vendors, that would not create this type of easement, as stated by the Maryland Court of Special Appeals and the Washington Land Company case 767 A. 2nd at 902, conferring a use to a portion of the public that does not create an easement by dedication for the entire public. But as I indicated at the argument, I think this is a rather tortured view of the sentence. It requires me to read the clause in the letter describing the agreement as an agreement to preserve the property's open space and attractiveness as modifying or relating only to the vendors. In other words, all three clauses there, preserve its open quality, attractiveness, and accessibility to the vendors, should be read as preserve its open quality of the vendors, attractiveness to the vendors, and accessibility of the vendors. The much more natural reading of the sentence, plain language reading of the sentence, is of the banks is saying that it agreed to develop the bank to preserve 1, its open quality, 2, its attractiveness, and 3, its accessibility to the vendors. The defense interpretation of this portion of the letter also ignores the beginning of the sentence and the entire context of the letter, which is describing an agreement reached following these meetings. That's how the sentence began, which were not meetings with the vendors, but meetings with a variety of community groups representing the general public. So I think the most logical reading of this letter is that it constituted a promise to develop a property, continue its usage by the public at large in an explicit effort to gain the public support for the development based, at least in part, on that promise. While it's not as explicit as it could be, I think this letter can be seen as at least some direct evidence as the intent to dedicate for public use or as an offer to do so. But more importantly, at the very least, I think this letter serves as circumstantial evidence supporting the testimony of Ms. Nahikian and the affidavit of Mr. Smith regarding the nature of the intent or of the offer expressed at that time. In addition, I'll point to Plaintiff's Exhibit Number 2, the August 18th, 1977 resolution of the Federal Home Loan Bank Board, as also providing some corroboration of the accounts of Ms. Nahikian and Mr. Smith, at least to the extent that it references in a general way the objections made by the various parties and the objection to the agreement that was reached to withdraw the objections. Again, in addition, I'll point to Plaintiff's Exhibit Number 2, the August 18th, 1977 resolution of the Federal Home Loan Bank Board, as also providing some corroboration of the accounts of Ms. Nahikian and Mr. Smith, at least to the extent that it references in a general way the objections made by various parties and the agreement that was reached to withdraw the objections. So the testimony of Ms. Nahikian and the declaration of Mr. Smith and the interpretation of Mr. Owen's letter that I believe to be supported by their accounts is also bolstered by what I find to be other circumstantial evidence of intent. That is, the way in which the plaza itself was constructed. It is a substantial open space with no fence or other lines of demarcation separating the plaza from the public sidewalk or street. These are permanent structures that were created on the plaza for public use. The raised brick platform the vendors use and raised porch or band shell for public events. These pieces of evidence were taken together to constitute at least some amount of proof of an intent by Perpetual to dedicate the plaza for public use, or to put it another way, to offer the plaza to the public for its use. As I stated earlier, for the dedication to be perfected, the public must manifest an acceptance of it. Importantly, that acceptance that must occur does not involve any action or require any action by any governmental authority or entity. As the Supreme Court of Georgia stated in Smith v. State 282 SE 2nd 76 at 82 in 1981, quote, acceptance by the public for public use is sufficient to complete the dedication without acceptance by the appropriate public authorities, end quote. The Maryland cases cited earlier, Gregneck Yacht Club and Washington Land Company, both state that the public can accept an offer to dedicate through one of four methods: acceptance of a deed or other record, acts in pay, such as improvement at the public expense, long use by the public at large, or express statutory or official action. Here, the plaintiffs appear to argue that the public has accepted the dedication through a long history of public use, and there's really not much dispute in what's been brought before me. The plaza has been used by the public in a manner consistent with the claimed easement by public dedication. As the witnesses described, the plaza has been used for a wide variety of public purposes, serving as everything from an informal meeting place to the formal situs of a farmer's market and other events. Once a finding were to be made that Perpetual intended to make a public dedication in 1976 and made an offer to the public, the history of the public's use of the plaza then makes the question of acceptance of the offer fairly obvious. Given all this, I think the plaintiffs have made a fairly strong evidentiary showing at this stage of the litigation as to the merits of their claim for a common law easement by dedication. However, this is not an uncomplicated claim, and there are numerous issues and problems that have been raised both factually and legally with respect to the plaintiff's claim, and I want to focus on what I view as the three more substantial issues. First, there's the issue relating to what that easement is, the parameters or boundaries of the claimed easement, and what would constitute an infringement on it seems hard to define, and that's an issue I raised at the argument last week as well. At the argument, plaintiff's counsel argued that the easement could be defined by fidelity to the dedicated purpose. It appears from the case law that he is correct about that, and that an easement can be defined in terms of the use permitted on the dedicated piece of property. For example, in the case of the town of Newfane versus Walker, A. 2nd 1074, 1076, and 77, the Vermont case in 1993 regarding the common law dedication of a swimming hole to the public. The court said, quote, the dedication here was an easement, but the scope of the dedication, not the nature of the property interest it conveys, determines how the public may use the property. What the easement allows is public entry for the full range of uses, primarily recreational, but some utilitarian for which the property was dedicated, end quote. Smith versus State 282 SE 2nd at 83 and 84 uses similar language in reasoning to describe how an easement by public dedication of a beach can be defined. Given that the easement here claimed is one defined by use, I don't believe that the broad and somewhat amorphous nature of the easement claimed precludes a finding that such an easement was dedicated. The second issue relates to who owns and who controls the property. The defendants forcefully argue that the exercise of dominion control over the plaza by SunTrust and its predecessors undermines the claim of easement by public dedication, and suggest instead that the private owner has permitted, licensed, or even encouraged public use of what should remain unencumbered private property. The defendants presented uncontradicted evidence regarding its responsibility for the plaza. SunTrust pays the taxes for the plaza. SunTrust pays insurance for it, and even settled a slip and fall case when somebody fell in the plaza and sued. SunTrust maintains the plaza physically by shoveling snow off of it, and so forth. Similarly, defendants point to something called the Police Regulation Amendments Act of 1981, which designated the Plaza Street Market, quote, provided that prior written consent of the owner of the property has been obtained for such purposes, end quote. There's evidence that was presented from several witnesses, including plaintiff's witnesses, that SunTrust issues licenses to the vendors who use the farmers market and to those who wish to use the plaza for other events and purposes. So, 3 points here I'd like to make about this evidence regarding SunTrust's control of the plaza. First of all, not that anyone has urged me to look at it this way, but I don't think it provides useful circumstantial evidence regarding the original intent to create an easement or whether Perpetual has made an offer of public dedication. Given the time lapse between the dates of the purported dedication in the mid-1970s and the testimony regarding the more recent treatment of the plaza by SunTrust or before that by Crestar, this evidence doesn't provide much of a barometer as to the intent of the parties at the relevant time, which was, as I said, in the mid-70s. Secondly, even if SunTrust had no specific knowledge of the easement and is acting now as if there were no such easement, that would not by itself affect the analysis. As explained by Heppy's Company versus Chicago 260, Illinois Reporter 506 at 514 from back in 1913, and the more recent Town of Newfane case 637 A second at 1077, a common law easement by public dedication once created is irrevocable and can be extinguished only if an easement is abandoned by the public, which hasn't happened here based on all the evidence of the current use of the plaza. So again, whether SunTrust knows of the easement or behaves as if there is not a relevant whether SunTrust knows of the easement or behaves as if there is not a relevant one since the easement, if it was created, it is irrevocable. Thirdly, related to all this evidence of control and dominion over the plaza, and perhaps most importantly, all of the defendant's evidence regarding its care and responsibility for the plaza, all of that evidence is consistent with SunTrust continuing to be the owner of the plaza in fee simple, with its ownership burdened by the common law easement dedicated in 1976 by Perpetual. In our oral arguments, defense counsel argued that a property owner who makes a dedication to the public relinquishes all control over the property. I think this argument conflates a dedication of easement with a dedication of ownership, and the argument is not at all supported by the vast bulk of case law. The DC case I cited earlier, Brown versus Conrail 717 A second at 315 footnote 7, again quotes Black's Law's Dictionary for the proposition that, quote, the dedicating party reserves to himself no other rights than such are compatible with the full exercise and enjoyment of the public uses to which the property has been devoted, end quote. The Court of Special Appeals of Maryland stated it more clearly in Flores versus Maryland National Capital Park and Planning Commission 103 A 3rd 1124 and 1130 in 2014, where it is said, quote, under Maryland law, when a parcel of land is dedicated as a street for other public use, the owner of the land retains its fee simple interest subject to an easement for the public, end quote. In the Vermont Supreme Court, and again in that Town of Newfane case 637 A second and 226, described it similarly, quote, a common law dedication, unlike the more formal statutory dedication, does not pass fee simple. Rather, it passes an easement to use the property in a manner consistent with the dedication. Use, not ownership, is the crux of the dedication. Even the Great Neck Yacht Club case cited by defense to support its argument, the dedication eliminates ownership of the property and actually says the opposite. It contradicts that position on explaining at 769 A second 986, quote, an easement is a non-possessory interest in the real property of another. If land is burdened by an easement, the owner of the servient estate is not divested of ownership of the property. Rather, the easement area remains the property of the servient state, end quote. Later, at page 985, the case uses the same language, a very similar language that I cited from Flores, noting that the owner of the property who makes a common law dedication of the easement, quote, retains a fee simple interest in the dedicated parcel subject to an easement for the public, end quote. So I go through all that to explain that the fact that SunTrust maintains, repairs, and insures the plaza and pays taxes on it is perfectly consistent with the existence of the claimed easement, as SunTrust remains the owner of that property in fee simple. Nor does the fact that SunTrust and its predecessors issued licenses to vendors and other uses of the plaza undermine the notion that an easement exists, whether that licensing stems from the Police Regulation Amendments Act or is undertaken independently of that. An easement by public dedication can have conditions attached to it. As the Court of Special Appeals of Maryland put it in Washington Land Company 776 A second at 900, quote, an owner making a voluntary dedication of its property in public use may annex such conditions and limitations to its grant as are not inconsistent with the dedication and will not defeat the operation of the grant, end quote. And there's been testimony that the licenses and vendor agreements, like the ones used in the plaza, are also used with regard to other public property, examples given in Walter Pierce Park and Eastern Market. In the end, the evidence regarding SunTrust's exercise of control over the plaza do not seem to be at this state to weaken the argument as to the easement by public dedication made by the plaintiffs. The third main issue I identify with the plaintiff's claim is the most substantial argument, I think, raised by the defendants. It relates to the nature and the weight of the evidence produced by the plaintiffs. There is no doubt that the plaintiffs, in supporting their case, are relying on people's memories from many, many years ago, going back 40 plus years, to attempt to establish the intent of Perpetual and its offer of public dedication. Ms. Nahikian and Mr. Smith provided what I view as the most direct evidence of public dedication. And I acknowledge, of course, that, as I must, that memories, particularly of something like this that happened so long ago, can fade over time. At the same time, these witnesses have no reason that I can discern to fabricate or exaggerate what they remember. Ms. Nahikian, in particular, is someone who doesn't even live in the community or in the city anymore. Their accounts, as I mentioned earlier, were corroborated to a large extent by what I view as the most natural reading, Mr. Owen's letter, and by the manner in which the plaza was constructed. And most importantly, this evidence regarding the dedication was not contradicted by any other evidence presented to me in the course of the hearing on the motion. As a result, I do credit the accounts provided by Ms. Nahikian in her testimony and Mr. Smith in his declaration. In applying the standard that I must here, I find the plaintiffs have shown a substantial likelihood of success on their claim that a common easement by public dedication exists. When I speak about the final two factors more briefly, first, with relation to the balance of equities and interest here, I find that the balance of equities also favors the plaintiff's position. Mr. Simons of SunTrust testified that an injunction would have a negative impact on the development, difficulty with getting title insurance, and going to closing. The very least it would affect is the timing of the property. And I don't doubt this ruling could have an impact in that respect. The most significant impact cited by the defendants, losing the financing and potentially blowing up the entire deal, is extremely hypothetical at best. I'll note that P.N. Hoffman, the developer, signed a contract for this development apparently several years ago, and it's been extended several times since then. Mr. Simons also testified at this point there's no start date for the construction project, and the branch is slated to remain in operation in its present building at least through December. The plan here, my plan, is to resolve the merits of this case as expeditiously as possible to minimize the potential impacts on the defendant. And if the plaintiff's case is ultimately shown to have no merit, then there's no specific reason that's been given or proven as to why the project could not go forward at that time. On the other side of the scale, not issuing the injunction would, as I mentioned earlier, entirely extinguish the plaintiff's interest before the lawsuit could even be concluded. Finally, there's the question of whether the public interest would be disserved by the issuance of the injunction. And I want to make myself as clear as I can here. I'm not here to make a determination about what the best use of this space would be for the public, whether it's better to have this whole plaza there or better to have a new condominium development there. I've heard a lot from witnesses called by the plaintiff who appear to care a lot about the plaza and the role that it plays in the community, and I credit their testimony that it does have meaning to that segment of the population that testified there and others like them. But I also think that reasonable, well-meaning people can disagree about which use is better for the community. I'm not assuming the role of the person making that choice. I'm not saying here the plaza is better or the condo is better than the plaza. The choice is not one that a judge can or should be making. In terms of what the public interest here is, I think surely the public interest is better served by maintaining the status quo while this litigation proceeds, again in an expeditious fashion. Rather than allowing the defendants to go full steam ahead with their project and raise this plaza in an irreparable way, particularly in light of my finding there's a substantial likelihood that further court proceedings would substantially result in a finding the project infringes on a public use easement, surely maintaining the status quo while the court process can proceed again expeditiously for the third time, I'll use that word, I think is what you'd want for the public. As a result of all that, I find the applicable factors all favor the grant of the injunction. I'm going to grant the motion for preliminary injunction that was filed by the plaintiffs, and I'm going to issue a brief order putting that order in writing today. Let me suggest also to you that the following before we go. As I indicated, I think it's in everyone's interest to resolve this matter as expeditiously as possible to get to the merits as quickly as we can. I know that the dispute has been going on for a long time, and based on the representations made in argument, there's a lot of what would be discovery that's already been done. And I know you all have a scheduling conference scheduled for sometime in October, something like that, September, October. I believe it's mid-September, says Mr. Zuckerberg. The court said mid-September. Mr. Zuckerberg said, yeah. The court said, I would suggest we issue a track 1 scheduling order today and just get the case going today. You won't have to come back here for the scheduling conference, and that way we can move this case forward as quickly as we can to get this resolved.